Hello everyone, I am Anuj Nakade and you're watching LiveLaw. In this video, we bring you a story from the Karnataka High Court about a bail hearing for the crimes under the Unlawful Activities Prevention Act or the UAPA. This bail hearing was for one of the accused in the 2020 Bangalore Riots. As you know, in the August of 2020, riots broke out in the KG Halli area of Bangalore in a horrible turn of events. A local police station was burnt and several vehicles were ransacked. As a result, several criminal cases were filed for unlawful assembly, rioting, assault, use of criminal force along with voluntary causing hurt and grievous hurt to prevent public servants from their duty under the Indian Penal Code and for causing damage to public property by fire or explosive substance under the Prevention of Damage to Public Property Act 1984. After obtaining approval from the competent authority, charges were also framed for the commission of terrorist acts and conspiracy under the Unlawful Activities Prevention Act. Due to the severity of the crime, the National Investigative Agency was directed to take up the investigation of the case in September of 2020. A total of 181 persons were accused in this incident. Imran Ahmed, who is one of the accused in this case, sought bail in several criminal cases against him from a special NIA court. This petition for bail was rejected by the special court in 2022. A two-judge bench of the Karnataka High Court had previously affirmed the rejection of the bail by the special NIA court in 3 criminal appeals in the High Court by the accused. The court was now considering an appeal filed by Imran Ahmed against the rejection of a bail in a 4th criminal case. A single-judge bench of Justice Krishna S. Dikshit heard the matter. In this proceeding, the accused had primarily argued that the court should consider the sanctity of basic human rights and the doctrine of innocence of the accused till proven otherwise. He also referred to the famous dicta of Justice Krishna Iyer, saying bail is a rule and jail is the exception. The prosecution, however, argued that there was enough evidence to deny the accused bail, as charges under the Unlawful Activities Prevention Act also introduce a negative burden on the accused to prove their innocence. After hearing the two sides, the bench noted that this lenient norm while deciding bail application evolved decades ago and in a case that involved offences punishable under the provisions of the Indian Penal Code 1860. The court said, and I quote, "Almost all the norms in a legal system, be it civil or criminal, are relative. They are bound to the society's calendar. With ceaseless run of time, these norms undergo change in their texture and color for retaining their relevance as a living law of the people. Norms of the kind cannot be chanted like a mantra or slogans in every bail petition out of the contextual circumstance." The court observed that in serious matters where after investigation, the charge sheet has been filed by the specialized investigating agency and there has been significant evidence against the accused, the court must prioritize public safety and collective interest over individual liberty as guaranteed in the Constitution. The court said, and I quote, "The NIA after investigation has placed on record abundant materials such as videographs and photographs of the incident, the mobile phone call records, mobile tower records, weapons used, the statement of the eyewitnesses including injured police officers, etc., that prima facie demonstrates that the appellant accused was an active participant in the said incident that was like a nightmare to the city life." The Karnataka High Court has now refused bail to the accused in this case as well, emphasizing that the fact that public safety and the collective interest of the society must be prioritized over the individual liberty as guaranteed under the Constitution. Placing reliance on a Supreme Court judgment in the case of Sunil Roy versus the state of Uttar Pradesh in 1998, the Supreme Court said, and I quote, "Keeping in mind the sanctity of human rights as recognized by the apex court in light of the constitutional guarantees, we are conscious to the possible societal implications should the accused of the kind be enlarged from confinement. We are of the considered view that the cause of justice would be served more by continuing him in confinement than setting him free. However, considering that there are several accused persons who have suffered the rejection of their bail petitions and as a consequence are continuing to be in judicial custody without proof of their innocence or guilt, the bench has asked the trial court to conduct a speedy trial and said they have a fundamental right to speedy justice, cannot be lost sight of. This is a fit case for a speedy trial, if possible, on a day-to-day basis. We are also aware of the burden that the learned trial judge of the special court shoulders. Hence, the accused Imran Ahmad has been denied bail in the UAPA case, but has been provided the assurance of a speedy trial. That's all we have for you in this video. If you would like to know more about this case or read the order, please visit our website at www.livelaw.in. We will also leave a link down in the description to the full article. If you liked this video, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.